Welcome to Fitzon's Property Exchange, hosted by Pearl Skeltimer, designed to keep you informed and captivated about the South African residential property market. Subscribe to our channel today and enjoy conversations with some of the most influential, innovative, and interesting industry experts, stakeholders, and scheme executives as they render input in today's property market.
Hi, good day, and once again, welcome to Fitzon's Property Exchange. I'm extremely excited to speak to the man of the moment about a thing that happened in our industry very recently. It has to do with the PPRA's initiative on BBEE compliances. So I am speaking today to Rudy Yearshop. He holds an LLB degree from the University of Johannesburg, which he obtained in 2009 and was admitted as an attorney of the High Court of South Africa in 2011. Rudy specializes in all aspects of law surrounding community schemes and High Court litigation. So, Rudy, welcome.
Good afternoon, Paul. Thank you for having me today.
All right, you're going to have to give us a bit of background. Please provide us some background as to where the PPRAs initially started with a BEE initiative.
Thank you, Paul. Okay, so before we go down this rabbit hole pertaining to the current BEE situation with the PPRA, let's look at the crucial definitions in the Act. So in terms of Section 48 of the Property Practitioners Act, it clearly states that a property practitioner cannot act as such without a valid BEE certificate. So that cannot act without a FFC, Fidelity Fund Certificate. So that's quite simple. We all understand that, we all appreciate that, and that was nothing new to the industry, especially if the property practitioner was a state agent previously.
Yeah.
What transpired and what the Act then introduced was in terms of Section 50X, which states that for you to have a Fidelity Fund Certificate, you must have a level of a valid BEE certificate. So that was something that was reintroduced, or which was introduced in terms of the Property Practitioners Act. Now, the property sector has its own scorecard when it comes to BEE status. So as an attorney, I do not subscribe to this specific scorecard, and property practitioners have their own. So there's various levels from level 1 and to level 8. And then, in fact, there's a non-compliant contributor, which states, for instance, if you your qualifications is less than 40 points. So I'm not going to go into the nitty-gritty of the point system. I'm not a BEE specialist. I'm an attorney, so I interpret the law and so forth. But what happened previously is that property practitioners complied with the legislation and they received a non-compliant contributor certificate. When they submitted that, the PPRA issued the valid or issued Fidelity Fund certificates. So there was no issue. How we saw and how we interpreted Section 50X as a valid BEE certificate, we were under the impression when it was introduced and the manner in which the PPRA acted was for data capturing purposes at best, because they don't actually say you must, because Section 50X does not say you must be a level 2 contributor or you must be a level 8 contributor. Just say
it just says compliance.
You must have a valid, compliance. So if you're non-compliant, you're still compliant with the Act because you subscribe to BEE, you filled in the form, you signed an affidavit, and they say, okay, you're non-compliant contributor. Doesn't mean that certificate is now you don't have a certificate. You have a certificate stating that you're non-compliant contributor. And that is how we interpret it. Previously, it would seem as if the PPRA also interpreted it in the exact same fashion. From 2021, 2022, 2023, they issued certificates based on these non-compliant contributors. However, as with everything in our country, it is subject to change. There's new CEOs, there's different interpretations, and so came March of this year. We first heard about it in a webinar where the PPRA uttered that they're going to make the minimum requirement a level 8 contributor requirement.
Yeah, I actually lost my breath when I heard that.
Yeah, I personally was of the view that perhaps that was a typo or that wasn't the intention, because if one strictly looks at the legislation, it doesn't say level 8, but be that as it may. We then left it for a short while. And then in April, they actually issued a notice that you now need to comply with being a level 8 contributor, failing which you will not receive your Fidelity Fund Certificate. Now,
which practically would result in closing down your business.
Yes and no. So what is the issue that we have here? Because when you look at the scorecard applicable to the property industry, there's 3 categories. You've got your exempt micro enterprises, your qualified small entities, and then your generic enterprises. So everybody who has a turnover, the property practitioner or the entities with a turnover less than 2.5 million is an exempt micro enterprise. So they don't have to conform with the VE status. So they're exempt from that provision, so they will be able to obtain a valid FFC. The property practitioners that I do business with and that I know in the industry, and I think Fidelity will get to them now, did a little study with Rebosa. It will affect up to, I think, 75 or 85% of the property practitioners out there will be affected by this, which means, between the EME, which is the exempt micro enterprise, and the generic enterprise, that's between 2.5 million turnover to 35 million turnover. That's your QSE of EME. QSE.
That's quite broad.
It is. It's very broad, and it's a turnover one. It's not profit. It's not gross profit, net profit. It deals with turnover. So, in most of the entities that we know and that we have deal business with will fall within the qualified small enterprise, which now mean you need to conform with this level 8. Now, for the level 8, you need 40 points. Now, you made the statement, well, I'm going to have to close down. Close down is a strong word because you can conform to the level 8. But if you look at the scorecard, and again, I'm not an expert, so my simple interpretation, ownership only counts for 27 points. So that would mean you need to give away, if you're a non-contributor, there's an issue with ownership. So ownership you're going to have to get a partner in. Management and control refers to 9 points and 11 points. Then you can do that. So previously you could have performed just skill development and obtained points, but you only get 17 points for that. Management and control, you only get 9 points for that. So everybody interpreted this as, okay, I'm going to have to partner, and let's address the elephant in the room. I'm going to get somebody that was previously disadvantaged in terms of the active fund to become a partner, and I need to change my business to actually take part in this economic sector. And that's where the issue lies. That's where we also take issue with this interpretation, because I do not read the act as that being the intention. The intention is just you must hold a valid VE certificate. It does not say the levels. And that was the issue for me when it actually was publicized that they're going to start, it's a minimum requirement. And then they actually refused. And they actually refused some property practitioners to reissue their FFC. So that was the issue. And that was here in May of this year.
Thank you very much for that broad explanation. It actually cleared up quite a few things for me as well. So who was the role players in taking the initiative to object against the PPRA's requirements or notification?
Well, I think the easier question is who did not object? So it is. I had meetings. I've recently had a discussion with the CEO of Rebosa. They objected from their side. Sarkolika also objected from their side. NAMA objected. Individual property practitioners objected. So it was actually the industry as a whole coming together and raising these objections. From my perspective and how I got involved is obviously when this was publicized, because I deal in the sector and my biggest portion from my business personally is the community scheme industry, obviously will then by implication mean property practitioners. I had to advise them on the status. It is what it is. We need to either conform or we need to object to that. At that stage, and with the compliments due to Sakeliga, they then ran with this application and they had a very, very quick response to it. And they started from...
Can I just stop you there? What exactly do you mean by application?
No. So I'll get to the application part now. Okay. So Sakeliga made contact with NAMA, and I represent NAMA. So we were in discussions as to how are we going to object to this. During that discussion, because we had to object. It's simple from an industry perspective pertaining to managing agents. NAMA got involved and they said, okay, we have to object to this.
Okay. The decision was as to... Just for our listeners, NAMA being the National Association of Managing Agents.
Yes, and they furthered the interest of managing agents with matters like that. And they also did a matter last year where it pertains to clearance certificates more on the body corporate side, where they also acted on behalf of their members. And again, it would have been a similar matter in this instance where we would have acted on behalf of the members, because NAMA gets mandated by their members to object to this. So during that stage, we were also invited to engage with Sakeliga. So Sakeliga also represented developers. They represented estate agents and also managing agents. So if you consider the definition of a property practitioner, it's a very wide definition. So the three parties just mentioned, everybody will fall underneath that. So Sakeliga represented the greater property practitioner, where NAMA had a narrower approach, representing only managing agents. So we were in discussions with them, but obviously we approached the PPRA on NAMA's behalf as well, not just through Sakeliga. We then, through my firm, we also demanded that we sit and discuss this matter. And at that stage, there was a time period where we didn't receive any communication from the PPRA, and we had to make a decision as to how we're going to proceed with this matter further. Are we going to launch an application where NAMA being the applicant? Are we going to join the application from Sakeliga as a co-applicant? So the intention has always been that we need to either resolve this problem amicably or that we need to go to court. And that's how we started. I think from an industry, and I must commend, and I've commended various industry sectors and people for coming together. But this was one of those things where everybody came together as a united front and objected to this. And there was a lot of pressure placed on the PPRA to reconsider the publication of this level 8.
I have to mention that as an individual, a property practitioner, the CEO of Fadzane Estates, very small company in comparison to all the huge ones, that it makes me feel so good that we have guys like you looking after our backs. Really, it does.
Thank you, Paul. Thank you so much.
All right. So what was your plan of action?
Look, at that stage, because we didn't receive any communication from the PPRA, it was difficult in deciding. Obviously, I'm an attorney, so my knee-jerk reaction is we go to court, we need to sort this out. But for people that know me in the industry, I'm a result-driven attorney. When we litigate, the previous matter that we took through to the Supreme Court of Appeal, that took us almost 2 years to resolve. And that was just the appeals book. That's a matter that came from 2021. So litigation takes long. And it's not always the best way to try and resolve the issues. But that's my style of litigation. I seek to obtain results for my clients. So through my persistence and with my relationship with the PPRA, I've hosted them, I've sat with them, we've done webinars together, seminars, and so forth. I explained to them that we are
That got you a foot in the door.
Yeah. Yes, we are going to launch this application. Rather speak to us than ignore us. And it's not just going to be normal. It's not just going to be my firm. You're going to be faced with various applications. They then afterwards make contact with me, Advocate Deborah Vale, that works for the PPRA, and said, okay, they reconsidered the issue, and that for now, they will be withdrawing the level 8 BEE requirement, minimum requirement. So that's how we actually resolved this. It was not through court papers, it was through discussions from my perspective. They then confirmed in writing to me that NAMA's members can now reapply for their FFCs, and they will no longer be disqualified based on the minimum requirement, the level 8 requirement, as previously publicized. So that publication from the PPRA was then withdrawn.
Wow.
Without us having to go to court.
Wow. I can't believe that you have achieved so much by just sitting around a table and discussing this. It's almost unheard of.
Yes, look, the thing is, from my perspective, I think that because of the industry, you must understand that, albeit that, and I don't want to use the word capitulate, because they did not capitulate. We'll get to that point now. They just said they're going to reconsider this point. But because of the industry, I think that motivated the PPRA to make some sort of communication or come back to some attorney who's been on record, because I'm not the only one who wrote to them. I'm not the only one who found it. But for some reason, they made contact with me and said, okay, we're happy your members can proceed. And obviously, it wasn't mentioned that managing agents can now apply, because that requirement is now being withdrawn. It's applicable to everybody, all property practitioners across the board who falls under the definition, from estate agents, developers, everything. So it's as if that publication never happened.
Sure.
So I think it was because of the collective, and I can reap the benefit by making the publication.
Wow.
I can't take all the accolades myself.
Okay, this is just why I needed to speak to you, just to inform our listeners of how amazing this actually was. So the notification is withdrawn. Last and final question, can we indeed count on the PPRA's commitment to keep to their undertaking of withdrawal, or do you think this will surface at some point in time again?
Well, it's difficult for me to say. I hope what was communicated to our officers, and it was I also circulated it to my client and its members, and they circulated it on social media as well. But what was stated by the PPRA is that they now going through obtaining legal advice through senior counsel in the interpretation, or to request their counsel whether or not the interpretation of Section 50X read with Section 48, the FFC and the BEE requirement, whether or not they can impose this level 8. So for now, we're in the clear. There is no requirement. Whether or not the opinion is going to be that they can implement it, and I think if it's going to be that they can implement a level 8, there will be a further consultation process. I think there will be more notifications provided than what they did previously by just saying it in a webinar. And then we will have to then go to court, because it is an issue of interpretation. Hopefully my knee-jerk reaction is that Section 50X does not say you must have a minimum level BEE before you can act as a property practitioner. That's my view. When one interprets legislation, you must look at the ordinary meaning of words, and nowhere can I imply that there's level 8. It does not say, it does not use a numeric number of 8, it just says that. Now, being non-compliant with the scorecard is also valid, and that is across the industries and various other industries. is accepted as such. So let's see.
All
Time
right.
will tell.
So
I don't want to make any. I don't want to make any guarantees on behalf of a third party. But what I can say, I think they will, if they'll have a more informed decision. I don't think it's just a decision around the table between the CEO and the directors of the PPRA making that. I think it will be a more informed decision. Whether or not they're going to implement it, I don't know. But they will give notice, and I'm still in discussions with them. So as soon as they let me know, I will let everybody know.
Okay, but for the time being, I can breathe. And I need to thank you.
Yes, for the time being, apply for the FFCs and get the.
Okay, that's luckily in process. If we could just get some response from the PPRA, that would be great. But yeah, it's in process. But thank you very much, Rudy. I really appreciate your efforts. I would like to thank NAMA. I would like to thank Sakaliga. And like I said, it's quite reassuring knowing that we have the big dogs looking after the puppies. I really appreciate your time, and thank you again, and we will talk soon.
Thank you so much, Bill. And if there's any clarifications from your listeners and from your clients, they can reach out to me, Rudy at shblaw.co.za, and I can clarify that, or they can just go on our website, contact me telephonically. I'm always here to assist. But yeah, thank you so much. And if there's any change, I will let everybody know of the changes. But for the time being, problem diverted.
Thank you. Much appreciated.
Thank you, Paul.
This was Fitzan's Property Exchange, hosted by Pearl Skeltimer. Not only do we keep you informed on the very latest in the property industry, we also empower by expanding your knowledge base. Make sure to visit www.fitzan.co.za to find out more about sectional title scheme management, letting, sales, and trustee training. Remember to subscribe to our channel and follow us on all our social platforms.